All right, everybody, it's about 2:30 West Coast time on Friday, December 27th. So I just put up a TikTok a couple of minutes ago saying that Donald Trump had filed an amicus brief, a friend of the court brief. He had filed it with the United States Supreme Court, asking the United States Supreme Court to put a hold on the deadline to ban TikTok on January 19th, because he feels like he should be able to make that decision. He wants that extra time to negotiate a deal, to do away with the necessity of the court to hear or decide this case. Essentially saying, if I can work out a deal, I can take this off your guys' plate and you don't have to worry about it. So I found the brief itself. It's 25 pages long. There's going to be some fluff in it, but I'm just going to I'm going to make this video to run through the brief and run through the arguments so that everybody can understand what's going on. So again, Donald Trump is not a party to the case. The two parties there are three parties to the case. It combined two different lawsuits. TikTok sued Merrick Garland over enforcement of this law, and a guy named Brian Firebaugh also sued Merrick Garland about enforcement of this law. And there's an et al. Behind his name. I think there were 7 or 8 different creators involved in that, and the Supreme Court combined these things, or the appeals court combined these things all into one case. And so this brief was written by John Sauer, Sauer, who was Trump's attorney arguing the immunity case at the appellate court level and at the Supreme Court level. He has done most of, if not all, of the appellate level briefing and argument on behalf of Donald Trump in his various cases. And Donald Trump has rewarded him by naming him as the incoming Solicitor General for the United States. So John Sauer will be arguing on behalf of the United States government in front of the Supreme Court and appellate courts for the next 4 years. Now, in these Supreme Court briefs, in this case, the Supreme Court, you gotta frame what you're talking about in these cases. And so in this case, with regard to the TikTok ban, the Supreme Court gave the parties the question to be answered. And the question that is presented that each side's brief has to answer is whether the Protecting Americans from Foreign Adversary Controlled Applications Act, the TikTok ban, as applied to petitioners, violates the First Amendment. So users of TikTok and TikTok itself, does the TikTok ban, that legislation, violate their First Amendment rights? Then we get to the table of contents. There are 3 sections to the argument section. That's the section that matters. And Trump and his attorneys have framed these sections of the argument that they want the court to consider as follows. This case's current schedule requires the court to address unprecedented, very significant constitutional questions on a highly expedited basis. That's true. I think they set oral argument for like January 10th. And I think the briefs are due probably right around now. So it was a really, really, really expedited schedule, something that the Supreme Court chose not to do when they agreed to hear Donald Trump's immunity claims a year ago. They set an unimaginably slow calendar for that case, which I think is a huge contributor to why Donald Trump is president today, because they basically prevented the January 6th case from going to trial. Section 2, 3 features of the act, meaning the law to ban TikTok, 3 features of the act considered in combination raise concerns of possible legislative encroachment on executive authority under Article 2. So what that section is going to say, I haven't read this yet, but what that section is going to say by reading this title is Trump and his attorneys are arguing that Congress overstepped their bounds as laid out in Article 1 of the Constitution, which sets up Congress, and they're bleeding into Article 2, which is the presidency. And they are encroaching on the authority of the president with this legislation and they're going to argue Congress is not permitted to do that. Section 3, the case presents novel, difficult, and significant First Amendment questions. Yes, it does. Then we have the table of authorities. Table of authorities is just the cases that are cited within the brief. Then we get to the introduction. Introduction and interests of amicus curiae, President Donald Trump. This lays out what his interests are. And in my TikTok, I highlighted this one paragraph that said, President Trump also has a unique interest in the First Amendment issues raised in this case. Through his historic victory on November 4th or 5th, 2024, President Trump received a powerful electoral mandate from the American voters to protect free speech rights of all Americans. He means white Christians who don't believe in vaccines, including the 170 million Americans who use TikTok. President Trump is uniquely situated to vindicate these interests because the President and Vice President of the United States are the only elected officials who represent all of the voters in the nation. Blah, blah, blah. President Trump did not win a mandate. He won this past election with a little more than 1% of the vote and did not win he didn't hit 50% of the vote share total. And he won re-election by somewhere around 200,000 votes spread across Wisconsin, Michigan, and Pennsylvania. If those three states had gone to Kamala Harris, she would be president right now. But because Donald Trump across those three states got 200,000 more votes than she did, he's president. Yay, Electoral College. There was another. President Trump is the founder of another resoundingly successful social media platform, Truth Social. This gives him an in-depth perspective on the extraordinary governmental power attempted to be exercised in this case. Extraordinarily successful. Okay, so the introduction section basically boils down to President Trump is the incoming president. He's going to be inaugurated the day after this ban is supposed to go in effect. And because of that, he should be involved in this process. And this court should give him adequate time to try to negotiate a resolution to the TikTok ban, to save TikTok and, become the hero of 170 million people. Let's see. Oh, Jesus Christ. In light of these interests, including most importantly, his overarching responsibility for the United States' national security and foreign policy, President Trump opposes banning TikTok in the United States at this juncture. That's a significant statement, and that statement is made on his behalf in a brief filed with the United States Supreme Court. Donald Trump opposes the TikTok ban. And seeks the ability to resolve the issue at hand through political means once he takes office. On September 4th, 2024, President Trump posted on Truth Social, in all caps, "For all those that want to save TikTok in America, vote Trump." Okay, I think we're done with the introduction, even though it goes on for several more pages. Summary of the argument: President Trump takes no position on the merits of the dispute. Instead, he urges the court to stay the statute's effective date to allow his incoming administration to pursue a negotiated resolution that could prevent a nationwide shutdown of TikTok, thus preserving the First Amendment rights of tens of millions of Americans while addressing the government's national security concerns. Okay, that's reasonable. There's ample justification for the court to stay the deadline. The court has aptly cautioned against deciding unprecedented and very significant constitutional questions on a highly expedited basis. Reasonable. If you move fast or too fast, you tend to break things. Second, okay, those are the three things from the table of contents. Okay, the argument section. He lays out the law where the court has the legal ability to grant such a stay. The court may grant a stay to preserve the status quo in a case that presents novel and difficult questions of great constitutional significance. Meaning, he's just asking the court to pump the brakes and leave everything as it is until he's got time to come in and do something. That reiterates that. He lays out some authority about why the court should do this, and that the court does have the authority to grant such a stay, and again cautions them not to do anything rash on an expedited basis that could harm the First Amendment rights of 170 million Americans. Then he turns to Section 2. 3 features of the act considered in combination raise concerns of possible legislative encroachment on executive authority under 2. And he's talking about the executive branch's power over national security and foreign affairs. These serious questions alone warrant staying the statutory deadline for more measured consideration. So essentially, he's saying that Congress is getting into areas of national security and foreign affairs. And his argument is that those are the exclusive purview of the executive branch under Article 2 of the Constitution. Article 1 lays out the authority of what the Senate and the House of Representatives, Congress, the legislative branch, are permitted to do, and they're generally not permitted to wade into these 2 areas of concern. They do things like budget and pass laws and ratify treaties and sex traffic minors. I'm kidding. Not really, but you know. Second, the statute purports to dictate how the president must exercise his national security and foreign affairs authority in this sensitive area. Okay, so he's saying that Congress is ordering the president how to conduct himself in national security and foreign affairs when Congress doesn't have the authority to do that. That's his argument. Then that's the bulk of it in that section. He says that they're overstepping. Yeah, the statute mandates that the president must make key foreign policy determinations through a specific dictated procedure, and he's saying they don't have the authority to do that. Section 3, the case presents novel, difficult, and significant First Amendment questions. Well, yeah, I mean, because what nobody in Congress has acknowledged, and what certainly none of the parties has acknowledged in any of these briefs, is that, and I've provided this context before, this bill to ban TikTok went from being nothing to being written, to being introduced at a congressional committee, to being debated at that committee, to being voted out of committee, to being put on the floor of the House of Representatives for a vote where it passed overwhelmingly bipartisan, then went to the Senate where it was put on the floor for a vote and it passed overwhelmingly in bipartisan fashion, and then Joe Biden signed it into law. That entire process took 8 days. That has never happened before, ever. And what was going on with TikTok at that time? A year and a half ago or whatever it was, over a year. Yeah, we were getting deluged with videos that were filmed by Palestinians inside the Gaza Strip about what the Israeli military, showing what the Israeli military and Netanyahu's Israeli government were doing to the Gaza Strip and to the Palestinians inside the Gaza Strip. AIPAC is one of the largest, most well-funded lobbying arms in the United States. And AIPAC is the reason that this bill got passed. And AIPAC is doubly the reason that it got passed that quickly. It's never happened before, ever. AIPAC basically owns our Congress. And it's like, and go back to Trump's first argument in Section 1. We need to slow this down so that we don't make a mistake, so that we don't do something with good intentions that ends up being harmful to 170 million Americans. That is, frankly, advice that Congress should have taken when they were working on this legislation and passing it in 8 days, because AIPAC told them to. There you go. Yeah, Congress should have taken that advice from Donald Trump. So, yeah, the case presents novel, difficult, and significant First Amendment questions. Over half of the American population uses this app, TikTok, every day. 170 million people. And Congress wanted to take it away like that because AIPAC told them to. Because that footage coming out of the Gaza Strip was inconvenient for the Israeli military and the Israeli government under Benjamin Netanyahu. And so they did it in 8 days. And it's like, why did Elon Musk buy Twitter, purportedly? To protect and preserve freedom of speech and people's access to things like Twitter. And the principle carries over to things like TikTok. Was there a Twitter ban that got through? No. And, so, okay, he just reiterates a lot of those other same arguments about national security, foreign affairs, and Congress overreach in this section. But again, I mean, it's not tricky to understand that when the government is banning a platform for speech that is used by 170 million Americans, it's not difficult to see how that could or probably should come with under the First Amendment, which starts off with Congress shall make no law. And then it goes on about, infringing the right of speech. Hang on, let me just look it up. I used to have it memorized. Congress shall make no law respecting an establishment of the First Amendment is just one sentence. It's got 4 or 5 sections to it. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people to peaceably assemble and to petition the government for redress of grievances. Congress shall make no law prohibiting the freedom of speech or of the press. And 170 million people in the United States use TikTok every day to express themselves through speech. Good argument. Yeah, good argument. So those are his arguments in his brief. Oh, wait a minute. There was another section in here. I'm going to read this. Let me find the beginning of this. Okay. By contrast, while purportedly applying strict scrutiny, that's the highest level of review that the court applies, the D.C. Circuit's opinion, the opinion that Trump's appealing, confers near plenary deference to the say-so of national security officials on matters of social media censorship. Let me read that again. Confers near plenary deference to the say-so of national security officials on matters of social media censorship. You know where I'm going, right? For example, in late 2020, federal national security officials likely misled social media companies into believing the Hunter Biden laptop story was Russian disinformation, which resulted in the wrongful suppression of that story a few weeks prior to the 2020 presidential election. And this deliberate campaign of deception was just another form of coercion. You knew we wouldn't get through this without some mention of Hunter Biden and his laptop. Ah, that is just fantastic. Okay, conclusion. Well, in short, there are compelling reasons to stay the act's deadline and allow President Trump to seek a negotiated resolution once in office. Conclusion. President Trump takes no position on the underlying merits of the dispute. He instead respectfully requests the court consider staying the act's deadline for divestment of January 19th, 2025, while it considers the merits of the case, thus permitting President Trump's incoming administration the opportunity to pursue a political resolution of the questions at issue in the case. All right, so that, and it's signed by John Sauer, James Otis Law Group, St. Louis, Missouri. Counsel for Amicus Curiae, President Donald J. Trump, and incoming Solicitor General. All right, so That's what this brief says. Those are the arguments that Trump is making. I largely agree with the arguments that he's making, you know, which that's a super fun position for me to be in. But, you know, hopefully that helps everybody understand what's going on here. And if you like this video, please go to our YouTube page. There's a link in my link tree. We're trying to build up our numbers over there just in case, because we don't know if the court's going to grant this or not. But I think they probably will. So, all right, everybody. It's Friday afternoon. Have a good, fun, and safe weekend.